So our next speaker needs very little in the way of introduction. He is Arif Ahmed, until very recently Professor of Philosophy at the University of Cambridge, where he helped orchestrate the campaign to ensure that the word tolerate was not replaced by the word respect in the free speech codes. In 2023, he was appointed Director of Free Speech and Academic Freedom at the Office for Students, where he is in charge of ensuring that universities comply with their free speech obligations under HEFSA. So he's an absolutely key figure in the campaign for free speech in the UK. Arif.
Thank you so much. Edward, can you all hear me? Thank you very much. One of the many hilarious ironies associated with my role is whenever a mic goes off or a speaker or feed cuts or something like that, people will laugh because of freedom of speech or something. So pleased to hear that it's not happened today. Great to see you all. Thank you very much for coming. Good to see so many friends and familiar faces here today and so many new faces as well. So thank you for being here. I propose to talk for about half an hour, 35 minutes, Ed, does that make sense? And then leave about 20, 25 minutes for questions. I'm here to talk about free speech and academic freedom in English universities and colleges. I'll start by saying a bit about what that freedom is for, and then I'll talk a bit about, in the keeping of the theme of today, its perils and prospects and how we might drive change through the sector. Freedom of speech is a fundamental human right, as you know. Without it, there is no possibility of self-expression. There are no new ideas. There is no productive debate. Without free speech, there is no social progress. No society is perfect, but a society that protects free speech contains the seeds of its own improvement. Without free speech, there is no challenge to conventional wisdom. Even if a view is wrong, you must be free to express it. Otherwise, how will you or anyone else know why it is wrong? The core mission of universities and colleges is the pursuit of knowledge. Freedom of speech, including the freedom of academics to teach and research, is therefore fundamental to their existence. I want to be completely clear about this. Financial concerns notwithstanding, this is not about balancing freedom of speech against such mere interests or concerns as external accreditations, relations with foreign governments, or potential donations. There is no balancing. There is no compensating for freedom of speech and academic freedom. Without them, what you have is simply not a university. Students benefit most when their education is underpinned by exposure to a very wide range of views. This creates the context for personal, academic, and professional growth. For many students, going to university or college is a formative experience. They meet new people from different backgrounds and are exposed to different views on social, political, scientific, and other subjects. It's a time of opportunities which for many is going to be life-changing. New students are going to hear, read, or study views that chime with or challenge their own perspectives. They're likely to encounter ideas that they may find shocking or offensive. Equally, others may be challenged by their own views, This is the purpose and benefit of higher education rather than something to be concerned about. And that purpose, free expression and debate of ideas, is now protected in law. Students have a right to express and discuss these ideas where that's done within the law. Discussing unfamiliar or uncomfortable ideas, when done in a peaceful, tolerant, and lawful way, enriches interactions with your fellow students and builds understanding of differences. Even if this doesn't change your mind, you will have considered the topic in a new light and you will have learned from the experience. But I can tell you now that academic freedom currently faces serious threats. I'll mention some of the recent statistical evidence that we have, and then I'll say something about themes in the reports that I've been seeing since taking on this post. Finally, in this part of what I've got to say, I want to make a brief point about something that struck me during recent engagement about different ways of understanding what a university or college is. And I want to point to an intellectual framework that might help to describe the dividing line that it seems to suggest. So I'll start with statistical evidence. We, the OFS, did polling of about 1,200 research and teaching staff in HE in England and published this in June of this year. We found that about a fifth, 21%, don't feel free to discuss challenging or controversial topics in their teaching. This rises to a third of academics from ethnic minority backgrounds. 16% of academics don't feel free to discuss challenging or controversial topics in their research, and more than 1 in 3 don't feel free in other contexts, such as speaking engagements and social media. In all of the contexts, teaching, research, and other contexts, female academics are more likely than male academics to say that they don't feel free discussing challenging or controversial topics. In particular, a fifth of female academics, so 21% in fact, say that they don't feel free in their research compared to 1 in 10 male academics saying the same, and that's a significant difference. A quarter of those, 24% of those who don't feel free in their teaching, cite fear of physical attack as a reason for not feeling free. This is consistent across tenure, sex, and political identity. So this amounts to 5% of all academics surveyed who say that they don't feel free because they fear physical attack. The latest edition of the annual Academic Freedom Index indicates that the UK was between 60th and 70th out of 179 countries across the world for academic freedom. This is well below other European countries such as Germany, Italy, Spain, and France. When compared to the 2014 index, the UK was one of just 7 European countries where a substantial and statistically significant decrease in academic freedom was identified. Similarly, in a recently published survey by UCU, the University and Colleges Union, of its members, with responses from 2,100 UK academics, so this is the UK now rather than England, which is what our statistics related to, but in this survey, 81.3% of respondents strongly agreed that academic freedom in research was important for well-being and performance. The survey focused on threats to academic freedom created by online institutional surveillance of research topics, methodology, outputs, and so on. The overwhelming majority of respondents, 87.2%, indicated that they thought that the current trajectory of digital monitoring would lead to reductions in academic freedom. That's the statistical evidence. I'm now going to say a little bit about what this means in practice in terms of the things that we've been seeing, and just highlight a few of the areas of concern that are on our minds. Happy to talk about other ones as well in the Q&A, but I'll just mention the things that we've been thinking about and want to think about further. I've heard from many academic staff about their experiences in the last few years. Now, for obvious reasons, I'm not going to repeat those stories, but I will identify 3 themes that are of special concern. I'm going to give examples corresponding to each theme, and they draw together elements of what we have seen reported. So they're not about real people or institutions, but they combine real elements of what's been reported to us. So everything in what you've heard has happened, but they've happened across different cases, but they're combined in a way that gives a sort of image of the kinds of things that we're seeing. The first area of concern is a broad area that I'm going to call compelled speech. So the Corporation Act, as you'll know, in 1661, and the Test Acts in 1673 and 1678 forbade public office to Roman Catholics and nonconformist Protestants. So the Test Act in 1673, for instance, which was said to be, when it was published, it was for preventing dangers which may happen from popish recusants and quieting the minds of His Majesty's good subjects. That requires any holder of a public office to swear, I do declare that I do believe that there is not any transubstantiation in the sacrament of the Lord's Supper or in the elements of bread and wine at or after the consecration thereof by any person whatsoever. This very blatant form of belief discrimination was finally abolished for Oxford, Cambridge, and Durham universities in 1871. But the idea seems to have made something of a comeback. Since commencement of the main free speech duties in August 2025, we've seen reports of belief requirements for academic posts. Here's an example which is fictitious, but it's made up of elements that we have seen reported. So this is an example of compelled speech. University A advertises for a lectureship in mathematics. It requires all candidates to submit a 500-word statement of evidence of commitment to equity, diversity, and inclusion. Another sort of ideological compulsion is evident in policies on pronouns. We have also seen examples of reports of examples like the following. Again, this is a combination of real elements. University B's Code of Conduct for Employees states, misgendering is never acceptable. You must always address or refer to a person using their preferred pronouns. So that's one area of concern that we have, compelled speech. Second area I want to mention is foreign interference. Universities and colleges are rightly jealous of their autonomy of the domestic government. And institutional autonomy is indeed one of the things to which we as the OFS must have regard by law. However, we've seen reports that universities and colleges do not always resist foreign interference with the same vigour. The following example is fictitious, but again, it combines elements from real reports. So in this example, Professor C lectures a course in law and human rights at University D. Some of the lectures cover abuses of human rights by the government of E, a foreign country. Nationals of E and senior staff at E's embassy in London complain to the leadership at University D. D suspends the course pending an investigation. Following a lengthy process, D takes no action against Professor C, but requires her to remove the elements of the course covering country E. The final area that I want to mention, I'll come back to these examples later, but the final area I want to mention here is institutional reputation. We've seen reports of universities and colleges subjecting academic staff to investigations and disciplinary processes because they have criticised the institution. There may be a risk that pressures of this type increase at a time of increased financial volatility for the sector. The following example is taken from our recently published guidance on the duties. This is Regulatory Advice 24. I've changed the letters just to be in keeping with the previous examples. College F imposes contractual obligations on its staff, including a social media policy requiring them not to post material that is unnecessarily critical of the college. During an industrial dispute, Dr. G, an academic employed at F, strongly but lawfully criticises the college's employment practices in a public post on social media. The college investigates Dr. G and issues him with a formal warning. So those are the three areas of examples that I wanted to talk about, and those, as I say, correspond to things that we've been seeing reports of, and I've been seeing since I came into this post. Both before and after the 1st of August, so when the new free speech duties came into force, we've engaged extensively with students, staff, students' unions, mission groups, and professional services bodies, as well as leaders and governing bodies of individual institutions, amongst others. When I've raised concerns, for instance, about ideological requirements in relation to applications, I've sometimes heard them say something like that. I've heard people say things like this. It's all very well to let academics say what they like, but universities and colleges have their own distinctive values, missions, and corporate goals. And these may include, for instance, something to do with diversity, equity, or free speech, or interfaith understanding, or international engagement. How can we stop our own staff from undermining our values or mission if we don't put expectations on what they say or think? Now, a narrow reply to this sort of objection would focus on the fact that legal duties override any preferences about institutional mission. Even where there might seem to be a clash between, for instance, the free speech duties and the public sector equality duty, it would be relevant and important that the latter, so this is a duty in the Equality Act, is a duty to have regard to certain needs, whereas the free speech duty requires universities and colleges to take certain steps. I can come back to that distinction later if helpful. But it's also worth taking a step back to think about what might lie behind this idea. And here I want to mention that the political philosopher Michael Oakeshott makes a helpful distinction here between two ways that people might engage and associate with one another, which is what he calls civil association and enterprise association. So putting this very briefly and crudely, and not doing justice to the subtlety of what Oakeshott says, the members of a civil association are each pursuing their own individual purposes. So an example might be the relation between motorists who happen to be driving on the same stretch of road. So here, the individuals each have their own interests and purposes, which they must accommodate to one another. The rules of a civil association constrain its members as the highway code constrains drivers. It doesn't tell you where to go, it only tells you how to get there safely. By contrast, the members of an enterprise association have some common aim or interest and are united to achieve it. The obvious example of an enterprise association is the modern corporation. Oakeshott's own examples include an army, a sect, a political party, a fire station, and a bassoon factory. The rules of an enterprise association are more or less determined by this common end. Soldiers in an army, for instance, cannot simply fight on whichever side they like, but must do as ordered. Senior officials in a political party cannot campaign for causes that run against the party's own political ends. Bassoon makers cannot spend their paid time carving flutes. Oakeshott himself was concerned with the implications of thinking of the modern state as a civil rather than an enterprise association. Here, though, I'd like to suggest that there may, at some levels and in some quarters, some influential quarters, be a related misconception about the state of our universities and colleges. if you think of a university as an enterprise association, then it will seem only natural to say some of the things I've been hearing. Only natural to seek to impose ideological requirements on your staff or to restrict speech by them that undermines your brand. But a university or college is an association of scholars, and as such it makes better sense to think of it as a civil association. I'm not the first person to suggest this. Jacob T. Levy is an example of a political theorist who said similar things. Scholars are, or if they are any good, they are independent-minded. And this means that they will each have their own ideas about diversity, equity, free speech, and everything else. And they must be able to pursue those ideas. It perhaps hasn't been better put than in the Calvin Report, which says the following: by design and by effect, a university is the institution which creates discontent with the existing social arrangements and proposes new ones. The instrument of dissent and criticism is the individual faculty member or the individual student. The university is the home and sponsor of critics. It is not itself the critic. It is, to go back once again to the classic phrase, a community of scholars. To perform its mission in the society, a university must sustain an extraordinary environment of freedom of inquiry and maintain an independence from political fashions, passions, and pressures. A university, if it is to be true to its faith in intellectual inquiry, must embrace, be hospitable to, and encourage the widest range, diversity of views within its own community. No doubt there is a wide range of both distal and proximal causes for the perils that I've outlined. Our own experience suggests that one of these may be the prevalence of an enterprise model of the university. A return to Oakeshott's civil model may turn out to be key to driving the cultural change that will be essential for any long-term improvement along this dimension. Here then is an intellectual framework that could help us understand a very relevant division of thought about what a university or college is. Well, so much for perils. What about prospects? And here I want to say something about the new legislation, about our guidance on the new duties, and about our future enforcement powers. And then I want to close by saying something about what could happen now. So a bit about legislation. In January 2025, the Secretary of State for Education made a statement in Parliament following the government's review of the Higher Education Freedom of Speech Act 2023. So this, as you'll know, I think it's been discussed earlier today, was an act of Parliament aimed at protecting freedom of speech and academic freedom at English universities and colleges. Following the decision, the main duties of the Act commenced, so they are now in force since 1st of August 2025. For universities and colleges, so these include colleges in a collegiate university like Oxford or Cambridge or Durham, these include a duty to take reasonably practicable steps to secure freedom of speech within the law, a ban on the use of non-disclosure agreements to silence victims of bullying, harassment, or sexual misconduct on campus, a requirement for all universities to have codes of practice to ensure the protection of free speech, and a duty to promote the importance of freedom of speech in higher education. For us, for the OFS, there are also duties on us, including a duty to promote the importance of freedom of speech. In the statute, freedom of speech means the following. It means the freedom to impart ideas, opinions, or information referred to in Article 10.1 of the Convention, as it has effect for the purposes of the Human Rights Act 1998, by means of speech, writing, or images, including in electronic form. We expect that any speech restrictions related to an institution's essential functions, which are teaching, research, and learning, or any other relevant factors, as well as any regulations related to these wider functions, would as far as possible focus on the time, place, and manner of the speech. We would expect that these measures, in intent or effect, do not ordinarily restrict legally expressible viewpoints. In other words, any regulation of the time, place, and manner of speech should be viewpoint neutral. And it should not be framed so broadly that it can be used to punish or suppress a lawfully expressible, legally expressible viewpoint. And just to emphasize the phrase within the law, so freedom of speech within the law is what is protected. All speech is lawful unless it's restricted by law. Any restriction of what is within the law must be set out in law made by or authorized by the state or the courts, so legislation or legal precedent or court decisions. So this includes, for instance, common law on confidentiality and privacy. But it does not include rules made by other institutions, for instance, universities or colleges, through contracts or their own regulations. So, for instance, there is no law against blasphemy in this country. If a university or college's code of conduct prohibits its students from insulting religion, it has not made the insulting of religion unlawful. If it imposes a contractual obligation on staff, on its academic staff, not to publish images that might offend some religions, staff who breach that contract are not thereby breaking the law. However, that code or contract may itself be unlawful. And although it's fact sensitive, in many circumstances of the type I described, it's likely that they would be. So it's likely that it would be unlawful to have a contract or code forbidding the insulting of religion, forbidding the circulation of images that might be offensive to some religions. As for academic freedom, the statute defines it as the freedom of academic staff within the law to question and test received wisdom and to put forward new ideas and controversial or unpopular opinions without placing themselves at risk of losing their jobs or privileges at their institution or at risk of a reduced likelihood of securing promotion or different jobs there. I should emphasize that in the Act, academic freedom is therefore not restricted to the academic's area of expertise. Parliament explicitly considered such a restriction and deliberately chose not to impose it. As the government minister at the time in the Lords said at the Grand Committee stage, when he was discussing an amendment that Lord Wallace had proposed, he said, that amendment to restrict academic freedom to your area of expertise as an academic, that amendment is similar to a previous provision in the bill that set out that academic freedom under the bill meant freedom of academic staff within the law and within their field of expertise. The government listened carefully to the issues raised during the passage of the bill in the other place, noting the concern that the definition of academic freedom was too narrow. In fact, the provision was a reflection of Strasbourg case law, and we were clear that it should be interpreted broadly, but we wanted to avoid any perception of such a limitation. We therefore decided that it would be appropriate to remove the field of expertise provision, which I think was this is the Minister speaking, which I think was a widely appreciated outcome. I hope the committee will appreciate that explanation of how the definition of academic freedom in the bill has developed. So that's a little bit about what academic freedom is, as well as freedom of speech, and a bit about its history. This means that academic freedom applies, for instance, to comments by an academic about matters of public interest, and importantly, to criticism of their own institution. It also applies to contributions to other academic disciplines. My friend, Ross Anderson, FRS, the eminent computer scientist and a great friend of academic freedom, who tragically died last year, once observed that it is these contributions across disciplines that are often both the most fertile and perhaps also the most vulnerable to suppression. One example that he might have had in mind was that of Alfred Wegener, the inventor of the theory of continental drift, a theory that geologists ignored for a long time, for decades, because its inventor was not himself a geologist. So that's the legislation. I'm going to say a little bit now about the guidance. On the 19th of June, the Office for Students published guidance on the new duties to secure free speech and to maintain a code of practice. This document, entitled Regulatory Advice 24, came into force on the 1st of August 2025 alongside the new duties. The guidance is in three main sections. Section 1 says what we mean by freedom of speech and academic freedom. Section 2 sets out a three-step framework for assessing compliance with a secure duty, and this is what's on the slide. These steps apply to any measure or decision that might affect speech or types of speech. The steps are, first of all, is the speech within the law? The guidance sets out what this means and gives examples of laws that make speech unlawful, and by law I mean statute or court precedent. Step 2, are there any reasonably practicable steps you, the institution, can take to secure the speech? If yes, take the steps. Don't restrict the speech. The guidance illustrates factors that are likely or unlikely to affect what counts as a reasonably practicable step. So not every step is reasonably practicable, but there are certain dimensions along which that assessment should run and other dimensions along which it should not run, and we say something about that. Finally, step 3, are any restrictions prescribed by law and proportionate under the European Convention on Human Rights? So you'll be aware that prescribed by law is something of a term of art, and it refers to the wording of the convention, the European Convention on Human Rights. It's not the same thing as within the law, or it's not the sort of complement of within the law. The guidance sets out that any restrictions on speech must be compatible with your duties under the European Convention on Human Rights, if indeed there are no reasonably practicable steps you can take to secure it. Section 3 of the guidance, so those are the three steps. Section 3 of the guidance gives concrete examples of steps to secure freedom of speech that are likely to be reasonably practicable in a wide range of circumstances. These are divided by areas of activities, like codes of conduct and research, and we expect to publish further examples in the future to reflect experience across the sector and our ongoing engagement with universities and colleges on these issues. So let me now, in light of the new legislation and guidance, return to the examples that I've mentioned concerning compelled speech, foreign interference, and institutional reputation. So I'll just go back now to the slide, just so you remember what the examples were. Both the requirement to evince ideological commitments and the blanket ban on misgendering are likely to be unlawful. In the case of the job advertisement, a requirement to equality, equity, etc., may penalise candidates for opinions or speech that have no bearing on competence in the relevant subject. In these circumstances, removing this requirement before advertising is likely to have been a reasonably practicable step that University A should have taken. Withdrawing the advertisement and re-advertising without this requirement is now likely to be a reasonably practicable step that University A must take. In the case of the blanket ban on misgendering, gendered pronouns are not merely nominal tags. They carry information that a gender-neutral designation does not. Describing a trans woman as he, or for that matter as she, may therefore express a belief about that person's sex. Indeed, this may be a legally protected belief. There may be circumstances in which the use of dispreferred pronouns could amount to unlawful harassment. For instance, repeated and deliberate misgendering directed by a teacher to a particular student in one of their classes may amount to harassment. However, we would expect that any code of conduct that regulates the use of pronouns on these grounds would narrowly tailor any restriction to those circumstances. It must not, in intent or effect, prohibit the expression of a lawful viewpoint, for instance, the viewpoint that trans women are in fact men, or that they are in fact women. Removing the ban as described is likely to be a reasonably practicable step that University B must take now. Foreign interference. So turning to Professor C's human rights lectures, it's likely that University D has failed to meet its duty to take steps to secure C's speech. We've been explicit in our guidance that the disapproval of foreign governments is irrelevant to the university's duty to secure the speech. This remains true however many students country E is sending to D, and whatever threats it makes to withdraw them. If the speech is lawful, then the university has a legal duty to take all reasonably practicable steps to secure it. It certainly has no legal duty and probably has no moral duty to appease whichever foreign despot that speech happens to irritate. Finally, on Dr. G's public complaints regarding institutional reorganization, we have again been explicit in our guidance that academic freedom generally includes speech that may negatively affect a university or college's reputation, including speech that's directly and explicitly critical of it. College F's policy and its action under this policy are therefore also likely to breach the new legal duty. College F should have considered taking reasonably practicable negative steps in this situation. These include not investigating Dr. G, not issuing Dr. G with a warning. They also include not imposing contractual restrictions on the speech rights of its academic staff. By contrast, a social media policy that simply required staff to be clear that all views posted are their own and do not represent the college's views would have been unlikely by itself to have breached A's duty to secure free speech. I'll say a bit now about next steps, finally about next steps. Although these legal duties apply to institutions from the 1st of August this year, they apply now, the OFS does not currently operate any enforcement mechanism that is directly tied to these new duties. However, we do expect those to come into force following forthcoming primary legislation. We expect a free speech complaint scheme to be open to staff and visiting speakers, not students, to bring complaints about certain types of breaches of the free speech duties. Students will continue to have access to the Office of the Independent Adjudicator complaint scheme for their unresolved complaints. The OFS complaint scheme is expected to cover complaints about providers, universities and colleges, or their constituent institutions, which means colleges, but not students' unions. We also expected to give the OFS the power to consider complaints at our discretion rather than an obligation to consider every complaint. In addition, whilst we are currently regulating free speech matters through our e-conditions that set requirements for management and governance, we expect that the new legislation will allow the OFS to impose a condition of registration tied directly to the new duties. The OFS's existing powers to enforce conditions of registration mean that it will be able to impose additional requirements on universities and colleges, to fine them, and ultimately to suspend or revoke their access to public funding if they are found to be in breach. Institutions might ask in this context whether this regulation is consistent with the spirit of academic freedom. After all, doesn't freedom mean, among other things, freedom from interference by, for instance, a regulator? The answer distinguishes institutional autonomy from the freedom of the individual. Academic freedom, as defined in the Act, is about the rights of individual academics. And where institutions are at risk of not securing these, it may make sense for a regulator, A, to guide them to do so, and B, to give them individual academics a route of redress. This is what the new legislation does. However, I want to stress in this context, just as I did 2 years ago, and I'll use the same words, that there is absolutely no question of the OFS seeking to conform university teaching or research to any political agenda. As I said then, freedom of speech is not the property of any one side in any culture war. It belongs by right to the whole human race, and for those of us who have it, nothing is more precious. As I also said then, this means that we take a viewpoint-neutral approach. It makes no difference at all whether you're in favour of Brexit or against it. I'm using the examples from last time, which some of them seem a bit dated. It makes no difference at all what side you take on statues or pronouns or colonialism or abortion or animal rights. You can argue that Britain is fundamentally racist or that it never was. You can speak or write as a Marxist, a post-colonial theorist, a gender-critical feminist, or anything else, as long as you do it within the law. You can even be rude about me, but obviously only up to a point. All of this remains true. None of it will ever change. I want to close by mentioning 2 things that I think individual academics can do now to defend academic freedom. First point is this. I mentioned before that one driver of what we're seeing may be a misconception of our higher education institutions as what I call enterprise associations. Another might be much simpler. University leaders are responsive to what they hear. Now is the time for individual academics who care about their most precious right to make their voices heard internally, as prominently and as frequently as necessary. If you see or hear about something that raises questions, bring it to senior leaders' attention. Point, if you can, to relevant sections of our guidance, which is there to help universities and colleges to navigate statutory duties on them that are now in force. I've said in the past that defending free speech is not always easy for leadership, even when the legal position is simple. But what will make it easier is internal support to do so. Very little could be more conducive to academic freedom than an environment in which it is both true and appreciated by decision makers that standing up for academic freedom is for them the path of least resistance. But making that so is up to you. But the second way for you to promote academic freedom is simply to exercise it. As Brandeis said best, but Pericles said first, the secret of happiness may be freedom, but the secret of freedom is courage. Right now is the time to invite speakers with opposed and controversial views, to set challenging texts, to teach syllabuses that are disruptive and uncomfortable. Now is the time to speak out where once you might have been wary. Governing bodies cannot unlawfully interfere with your exercise of these rights, and indeed where the Act requires it, they are obliged to protect you. And your example will embolden others. So I'll quote with a rough paraphrase of Tocqueville, though I don't think he said exactly this. He said, in the long run, it may be that nothing is as protective of liberty as a people for whom its use has become a habit. Thank you.
Okay. Any questions for Arif Ahmed?
Hello, I'm Stephen Greer, Emeritus Professor at the University of Bristol Law School and Research Director at the Oxford Institute for British Islam. I'd like to ask a question about the criteria the OFS uses to decide whether or not to conduct an investigation. And if I might give a hypothetical example, let's assume that a member of staff is exonerated from a student campaign to have him or her ousted for various views, Islamophobia, transphobia, whatever it might be. but the university in question takes the module, the offensive module, off the syllabus, and thereby instigates a climate of a chilling climate and self-censorship, not only at that institution but elsewhere. Is that the kind of thing the Office for Students would investigate?
Yeah, thanks very much. So I'll say a couple of things about that. First of all, in terms of the broad sort of area that you're describing, it seems reasonably close to an example like the foreign interference example. Clearly, the example you're describing it doesn't involve foreign interference, but that sort of hypothetical example where you have a student campaign to have a lecturer, for instance, taken up a course suspended, or a lecturer disciplined because of what they've said, and what they've said is lawful, we would expect the universities and colleges to take steps to protect the professor's speech, and if they did unlawfully interfere with it, if they had an investigation and then punish the professor, if they required them to remove elements of the course, that may well be a breach of the duties. Now, you had a question about investigations, and I guess there's a couple of things. There's a bit I can't say much about, and there's a bit I can say a bit more about. So in terms of deciding whether to investigate and what to do, or how to launch investigations, the OFS follows a process that's set out in a document called Regulatory Advice 15, which sort of talks about the steps that we have to do when we think about monitoring and then intervention. And of course, investigation is one step in the intervention process, and all the criteria that we are allowed to think about and that we are not allowed to think about when we take that decision. The other thing I will say is that that does not necessarily apply to what will happen when we have a complaint scheme. So we're expecting a complaint scheme to be coming in following further legislation, and that will be different from these sorts of investigations, because it will be through a complaint scheme where you have an individual complainant and the OFS has a relationship with that complainant. The way it now works is you have someone who sends us what's called a notification. The OFS adds that to its intelligence about the university or college, but it is not a complaints handling body. So we expect to become a complaints handling body with respect to free speech following that legislation, but currently our approach to registration and to notifications and so on, as set by statute, is not of that type.
Arif, thank you very much. I understand that the new Act, contains an instruction to the sector, the university sector, to take positive action to facilitate and protect free speech. And I wanted just a little bit of advice, and this is completely sincere because it's beginning to worry me. If in one of my discussion groups, the group take a decision together that in order to discuss something as difficult as, because this comes up a lot, Israel-Palestine, but they decide amongst themselves that in order to have this discussion, they may avoid using certain terms in order to have the conversation. Now, the point has been made to me by a lawyer that actually that could constitute, and I'm not being funny here, deprivation of free speech, because there will be inevitably be somebody in that group who thinks, yeah, I don't really want to agree to this removal of this term, because I think it's crucial, but okay, I'll go with it for now. And to me, this is a real fulcrum issue, because the only way I think at the moment that I've got the capacity to facilitate this within the sector, and I work with about 30 universities at the moment, is to set up these discussions where there is a common trust and an agreement among the people present. But then one student might go away afterwards and think, do you know what, I think that actually was unacceptable. So I wondered if you have any advice for me.
Thanks so much. Yeah, excellent question. So I can say something in general terms, and I'll try to say a little bit about the specific kind of case that you raised. So the first general point is that, of course, you're right, as well as what you might think of as the hard-edged duty to secure freedom of speech, which is the one I've been concentrating on today. There is also a duty to promote the importance of freedom of speech in higher education. We think of that as something where universities need to take active steps, but I want to encourage them to be exploratory in the way that they do so, to do what's probably going to be in the long run the most important thing, which is changing the culture within institutions around freedom of speech, and encouraging students to talk in a tolerant and peaceful and rational and constructive way about really difficult issues such as Israel and Palestine. So evidently that kind of work is vital, is crucial, really pleased that it's happening, really want to encourage universities to do it. In terms of the specific example you mentioned, one of the things that we say with regards to the duty to secure freedom of speech is that the steps you take have to be reasonably practicable. And whether a step is reasonably practicable depends on whether it interferes with the essential functions of a university. And the essential functions of a university, they don't get to decide them. We say what the law says what they are. They are teaching, learning, and research. That's it. And any admin that's necessary for those things to happen. If there are restrictions on speech, so for instance, if you think about a classroom, there are restrictions on bringing in irrelevant material, constantly interrupting people, asking questions all the time. There are various kinds of restrictions that are clearly, it's not reasonably practicable to relax them. Now, it may be that some of the cases of the type you described fall into a similar category. Clearly, they're more sort of semantic rather than formal, but they may fall into a similar category. Other ones would not. But it may be that in a lot of cases you just can't have a discussion at all unless you have certain kinds of rules on the discussion. But it will be highly fact sensitive. The other thing that I will say is that whether there's a breach of a legal duty will depend on who's doing the thing. So for instance, the legal duty is on the governing body of a university, and whatever it does, either by itself or by delegation. So if there's some sort of extramural, voluntary group, for instance, or something that's not part of the class and they aren't formal rules or rules set by the classroom, that could well change the assessment as well, because it could be that nobody's breaking a legal duty on them, at least as far as the Higher Education Freedom of Speech Act is concerned. You do also, obviously, any public authority has to think also about its obligations under the convention, so the European Convention on Human Rights, which in some ways encompasses more things, but in other ways is less strong. So that's an additional thing to think about. But broadly speaking, I would say I could envisage circumstances where the things that you're describing are likely to be helpful, but I would want to be cautious because it's always very fact sensitive.
Okay, we've got a lot of questions, so can we keep them short, please?
Hello, I'm Teresa Bejan. I'm a professor of political theory at Oxford. I just wanted to push you, for me it's a philosopher's question, but I want to push you on your use of Oakeshott. So the civil association versus an enterprise association, I mean, I think I can recognize and agree with you that a university is not a corporation in the modern sense, like a joint stock company, but it is fundamentally if not the medieval corporation. So I think Jacob Levy, whom you cited, I mean, he says that a university is a complex association, much like the Catholic Church. It's not an association of individuals, it's an association of associations. So we might think of academic disciplines as having their own norms, having their own expectations of participants within them. What the university must do is then make it possible for those subsidiary groups to pursue their ends in light of this overarching end. So it just seemed to me that you sort of put the civil association idea there, but it doesn't actually really explain then your own description of a university that followed. So thanks.
Thanks so much. You actually, yes. So you, of course, you're quite right to push me on my interpretation of Oakeshott. So Oakeshott didn't think this. So this is a distinction that he made that can be helpful, I think, for understanding some of the thinking behind this. Oakeshott, as you know, the stuff he wrote about universities and colleges was different. Didn't sort of use the language of on human conduct. Jacob Levy's sort of work, I'm thinking about work he did, I think, back in 2016. But you're right, this is not something that he massively developed. The reason I think it's important sort of goes to the point that you were making in the second half of your question, which is that academic freedom has been and often is indeed interpreted as a kind of not just to do with the institution as a whole, but to do with what you might call the freedom of the faculties, or the freedom of the sort of sub-bodies within the institution. That is a way of thinking about academic freedom. It is not the way we think about academic freedom. Academic freedom is an individual right. Faculty does not have the right to say, we as a faculty think this, and you, academic, can't teach this thing in your course because we as a faculty want to promote this. And if a faculty does that and says, we're doing that because we have academic freedom and the government can't interfere with that, the answer is that's not what academic freedom means in legislation. Other people have used that word to mean something like the thing you described, and you're quite right to point it out, but I'm grateful for the question because it gives me the opportunity to emphasize that, and this is one of the ways in which civil association, I think, is a helpful way to think about it, to emphasize that academic freedom as we think of it is an individual, not a collective right.
Okay. Nigel Warburton. I'm a former academic, fortunately. What you were saying about pronouns, does that apply to proper nouns as well? So, for instance, if you tell me your name is Sarah, Arif, you tell me your name is Sarah, and I refuse to use that name, are you going to defend my right not to use your given name? And if not, what's the subtle difference? And just to add to that, with the pronouns, there are so many easy ways of avoiding that conflict. I can't see a situation where it's not harassment, where you would, I can use they, I can use their actual name. Maybe if I use your name, Sarah, I may have a problem there as well. But it seems that I can't imagine a situation where that's not a kind of harassment, particularly in a teaching situation where you've got the authority of being the teacher and you have a student, possibly in a group of their peers, being humiliated by that absolute refusal to play along with that game, as it were.
Thanks very much. Excellent question. So again, there's sort of two parts to it. So with regards to the first point about proper names versus pronouns, I won't get here into a debate between whether proper names have descriptive content, for instance. I always disagreed with Kripke on that. I thought Russell was more likely to be right about that, nor the issue about the sense of a proper name versus the force or the other things that are achieved by using a particular kind of proper name. But I will say that in the case of pronouns, they can be used to express particular views. And the view that's expressed, for instance, by using the pronoun he for someone who is a trans woman, if that's the view that trans women are not in fact women, there is nothing unlawful about holding that view, and there is nothing unlawful about expressing that view, and or indeed the opposite view, that a trans woman is a woman. Moving on to the point about harassment, the test for harassment in the Equality Act, as you know, is about whether it creates an offensive, intimidating, hostile atmosphere, and it's crucial that it has to be whether it would be reasonable for it to have that effect. The mere fact of, for instance, a professor or an academic expressing their views, perhaps in print, for instance, perhaps in a speech, perhaps in a lecture, describing the view that in fact trans women are not women, in itself would without further be very unlikely to amount to harassment, particularly in an academic context. Yes, that's correct. So certainly words can be used in different contexts to express different views. I'm thinking of a context in which those words are being used to express that protected belief.
Michelle Shipworth, University College London, and I must say that that particular example resonates quite strongly with me. I would like to think of students A and B who are on that course. Student A would like to speak out against their particular country, which is foreign government E. And whereas student B, on the other hand, is most anxious to protect the interests of foreign government E. And student A is very concerned about the potential or actual harassment that they might receive from student B if student A was to express their views. And student A might even be concerned about what might be the consequences to them physically when they were to return home, and the consequences to their family as well at home. And what we can do in that situation to protect the rights of student A to speak their mind about country E.
Thank you so much. I agree with everything in that, and it's important to point out it raises a related but distinct issue. So here is the issue about academics who are being prevented or threatened when they raise material that's critical of a foreign country. You also have an example where you have students, both of whom might be nationals of that country, for instance, and one of whom either is or reasonably fears being harassed, monitored, coerced, surveyed by the other. You're right that it can happen through harassment. It can happen through, for instance, we've seen reports, many here will have seen reports, for instance, of a student who asks a question in a lecture, and the next thing they know, they'll get a phone call from their parents back in the home country who have been visited by the police because they were recorded and they were reported back. We are clear that we will not tolerate, and universities should not tolerate, conduct of that type. And so, for example, example 25 in our regulatory advice discusses an example of that type where you have the potential for harassment for students from a certain country engaging in activity of that sort. So that would be, so you're quite right, that's another example that would fall within the scope of the free speech duties. Not addressing this is something that would be a breach of the duties now for the universities. When we have enforcement mechanisms through a complaint scheme and a condition of registration, this is something we would expect to look at, but we are already looking at it, and we already have, as you suggested, quite well-developed concerns and interests around the activities of particular countries in this area.
Hi there, Nathan Skeen from Imperial College here. So I just want to raise a couple of issues that sort of just generally affect, I think, most academics. So one of them, you've discussed some of the issues of sort of compelled speech with the pronoun issues, but it's just utterly routine, I think, for any academic applying for money or having already received money. Like the other day I went to a conference for various grant holders and had to give a speech about, you know, what I'm doing for diversity and equality as a holder of that grant. how do we get rid of these things? It's not appropriate for academics to have to stand up and preach on a particular political viewpoint. Then you get, the sort of chilling environment of, our departments have to pay for political commissars. We have Athena Swan representatives, people who have to write grants for these things, and the departments know that they will lose their funding if we do not pay for these political commissars. So what do we do about that? How do we get rid of these things? It's not acceptable for universities to have to do this. And then you just get the practical restraints of, if we want to go off and do research with something like the UK Biobank, so something that's outright funded by the UK government, that puts explicit restrictions that will not permit freedom of the things which we wish to research on it, and will explicitly block research on certain areas. This is government-funded stuff. It should not be legal to do that. And yet, it's utterly routine on anything in genetics that they prohibit whole swathes of research.
Thanks so much. So I guess there's a couple of things to say there. First of all, the caveat that I would start by making is that, of course, universities and colleges do have various equality duties. So as public authorities, they do have a public sector equality duty. They do have a need to have regard to those things. And I think in many ways it's quite right that they do so. So they should, for instance, and I think it's right that they pursue, for instance, they may want to think about representation amongst the applicant pool for jobs, for instance. That's something they might want to think about. If there are students who feel excluded for whatever reason to do with a protected characteristic, there are various ways in which they may want to address that. I think it's quite right that they do, because there are issues here that definitely need addressing. However, they must always do that in a way that's consistent with their freedom of speech duties, and this cannot include, for instance, requiring you to pass some kind of ideological test in order to conduct research, in order to work for the university, or anything else that's within its control. Now, I can't say anything about specific accreditations with specific bodies. I mean, there are issues to do with, there may be issues with particular accrediting agencies. There may also be issues to do with, for instance, we drew attention in our guidance to potential issues about professional statutory and regulatory bodies as well. So these are bodies that are associated with particular professions that can put speech requirements on students who are training for those professions that may go beyond what the free speech duties require. And we've said something about when that is and when that isn't appropriate. But certainly, in broadly speaking, it would not be lawful, for instance, for universities to sign up to accreditations or other agreements where that involves, where we're signing up to it, involves themselves having a policy which unlawfully restricts research. And I was concerned to hear about the type of example that you're describing. And if you or anyone else has examples of that type that you would like to tell us about, then please write to the Office of Students, and we would be interested to hear about that. As I said, we don't handle complaints at the moment. We're not a complaints handling body. We will be expecting to handle complaints following the new legislation that brings in these powers, and there'll be a new condition of registration. But we're always keen to hear if there are specific issues about particular areas of scientific research, and I can totally see how genetics might be one of those, where you don't have the freedom to do research. You have to distinguish, of course, restrictions on what conclusions, restrictions on research because of the conclusions it might reach, versus, for instance, decisions about what broad research area you want to do. So a university might very well think, well, our priority is going to be AI, it's not going to be genetics, or vice versa. That's not necessarily something that's going to be unlawful. In fact, in many cases, universities just have to make those sorts of decisions. But when it becomes more sort of micro scale and managing particularly what research projects you do, particularly when there are concerns about what conclusions you might reach, then there is potential for breaching of academic freedom, yes.
Hello, Ian Pace, City St George's and Luca Fanafaf. You've partially answered my question about whether it was all right at this stage to be writing to you and to writing to the OFS, because thinking about what you were saying at the end, I mean, whilst trying, as many of us are doing, to raise the issue regularly and do things, some of us get treated like just one lobby group, even though we're wanting to get this is the law, not just one interest group. In that respect, it seems to me that not that many people in academia have yet read all your regulations yet, or are aware of them. It's going to take quite some time to change that. But if we can do that, there's just another question which is it's not particularly clear, I would say, in the regulations. I mean, you have a lot about documentation of processes when it comes to recruitment in particular. What I don't recall being mentioned is the process of shortlisting, which I think is where some of the biggest political gatekeeping happens? And is there anything you might elaborate on about the need to sort of document or have monitored the very process of shortlisting applicants? Because I see departments often want to make sure that by the time you get to a shortlist, they've already eliminated anyone who might be a problem in that respect politically.
Terrific, thanks very much. So just to deal very briefly with the first part of your question, yes, of course, we are always interested to hear from colleagues about, from academics about any, or students about issues that they see. With regard to the dissemination of the regulatory advice, of course, that's something that's going to be ongoing, and I'm working hard to make sure that universities and colleges are aware of it, and anyone who has an interest in doing so, I would suggest you point to it wherever it's applicable. With regards to the point about shortlisting, so you're right, we do have some material in the guidance about the process for appointments and about training for people who are involved in appointments and documenting where freedom of speech issues arise, giving an explanation of why, if there's a suspicion or there's a prospect that freedom of speech issues might be engaged, that be documented. But I think what's going to be helpful here is just universities and colleges constantly being aware that things are going to be very difficult for them if, in a variety of ways, if they think if they think they can get away with breaking the law. I'm not suggesting that they're doing that, but I would say that if they think that somehow it's going to be all right and think it can get away with anyone can get away with hiring on the basis of a political test, for instance, I do want to be completely clear that would be a breach of the law.
Last one.
Yeah, Jim Butcher, Academics for Academic Freedom, Kent and Canterbury branch. All of the examples, Arif, that you've gone through to me are clear. They're kind of clear-cut. Things are compelled, prescribed, prescribed, or you can make a strong case for that. But what I'm interested in is where things are morally affirmed or where a moral expectation of behaviours, languages and beliefs, because that seems to be where the debate is going and where the problem is around net zero, climate emergency, pronoun use. The university has deniability, but they've kind of said, if you're a compassionate person, this is what you do. Now, anybody who's new to the profession is going to look at the writing on the wall and conform, and that's the problem.
Thank you very much. Yes, again, you put your finger on a very important point. What I would say about that is that we do say that universities not only mustn't compel, but they also mustn't put pressure on academics, for instance, to accept particular points of view. And it could be that certain kinds of activity of the type you're describing would count as the sort of pressure that's likely to be unlawful. To give examples of why that might arise, it may be different in different contexts, but imagine if you're, for instance, an academic on a short-term contract that's due to be renewed. It may be likely, there may be a strong case that you're going to feel pressure from statements like that, whereas a professor who's got much more security may be less likely to feel that sort of pressure. Similarly, if you're a student, you're in a more vulnerable position. So I think the power relations in these situations can be relevant to how much of an effect, what we would call a chilling effect, for instance, there is in these kinds of situations. The second thing I want to say about that is that in addition to that, a very important element of it is to do with the duty to promote freedom of speech, I think. And whilst it may be true that there is, within universities, a moral consensus in one direction or a moral consensus in another direction, what there should be is an overriding moral consensus that any such consensus should be challenged. And that what most people believe probably is what is most important to challenge. And that's something, ultimately, I think, that law by itself cannot bring about. That's something that requires cultural change that's going to come, I think, best through universities meeting their promote duties and actively promoting freedom of speech and doing things themselves, what they have been really good at doing, which is just being sites where they can disrupt people's minds and disrupt people's thoughts and make people question perhaps their most deeply held and most cherished beliefs.
Okay. Thank you very much, Arif. That was great.